maybe after season, this would be spring following the winter this morning. So we're running a little behind again. I think I'll just cut introductions short. We're starting with Anna Single, who is an associate professor of law and associate director of the Indigenous Law and Policy Center at Michigan State University College of Law. Professor Single is going to introduce the VAWA Reauthorization Act and speak to its effect on tribal jurisdiction.
Good morning, everyone. Thank you so much for being here, and it's an honor for me to be invited to speak here today, so thank you so much. And today I've been asked to talk about the VAWA's reauthorization in 2013 and to provide an introduction and overview of VAWA's special provisions for criminal jurisdiction for Indian tribes. So this is going to be a somewhat basic overview, and so I just want to apologize in advance for those of you who are already familiar with VAWA's requirements. I want to begin by discussing some of the background that leads to the reauthorization of VAWA in 2013 with its special Title IX criminal jurisdiction provisions. So of course we all know that that there's a significant need for the special provisions in VAWA that relate to tribal criminal jurisdiction. And we know that much of that has developed as a result of the substantial gap in criminal jurisdiction within Indian country. That although tribes have historically, traditionally exercised full jurisdiction within their territories prior to contact, that had in practical ways been diminished over time. But then in 1978, the Supreme Court determined in Oliphant versus Squamish Indian tribe that tribes lacked criminal jurisdiction over non-Indians. And so this created a very substantial gap in tribes' ability to provide protection for their communities and specifically protection for American Indian and Alaska Native women. We also know that as a result, or perhaps not as a result, but certainly enhanced by that jurisdictional gap, there has been a growing rate of sexual violence against women within Indian country. And the statistics which have been compiled by the Department of Justice are quite horrifying. There have been a number of reports which have documented findings and compiled testimony of women related to their experience with sexual violence in Indian country. The Department of Justice reported, for example, that American Indian and Alaska Native women were more than 2.5 times more likely to be raped or sexually assaulted than women in the United States in general. And that more than 1 in 3 of all American Indian and Alaska Native women will be raped in their lifetime. Furthermore, data collected by the Department of Justice has also indicated that in at least 86% of reported cases of rape or sexual assault against American Indian and Alaska Native women, the perpetrator is reported to be non-Indian. So in practical terms, what that also means is that if you are an American Indian or Alaska Native person, every one of us knows somebody who is either a mother, a daughter, an aunt, a grandmother, a sister, who has been impacted by sexual violence in their lifetime. So what has contributed to these terrible statistics? Well, on the one hand, we know that there has been long-term violence against Native women, but much of this has been contributed to or by the failure of all of the governments, both federal, state, and due to the jurisdictional gap, tribal, to protect Alaska Native and American Indian women. So I'm going to focus on this, the jurisdictional needs within Indian country and the federal and state roles in contributing to this failure to protect American Indian and Alaska Native women and the tribal jurisdictional gap that led to tribes' incapacity to protect American Indian and Alaska Native women. So the federal role in contributing to this failure There's a number of different factors here which I've outlined, which I'm sure that you are all familiar with. But of course, number one, historically, the federal government has failed to provide sufficient funds for tribal law enforcement, for tribal court development, and also sufficient funds for health service providers within Indian communities. So as a result, tribal law enforcement agencies have been understaffed and have not had the facilities and training to provide adequate response. Courts had not historically been developed within Indian country, and there had not been sufficient training for health service providers so that they would be able to identify and provide culturally appropriate responses for women who requested their assistance. There's in groundbreaking reports, for example, by Amnesty International's Amazing Injustice Report, published in 2007. This evidence is also documented, and there are disturbing stories of individuals who have experienced these encounters, for example, with health service providers who were not trained to be able to identify and provide adequate assistance for Native women who had experienced sexual violence, and who in some cases were treated as though they were merely stereotypical drunk Native women, for example, rather than individuals who required immediate assistance for sexual violence. In addition, another contribution to the failure to protect American Indian and Alaska Native women is the federal government's denial of tribal jurisdiction. So just as I mentioned that the Supreme Court had determined in the Olivan case in 1978 that tribes lack criminal jurisdiction over non-Indians, that decision, of course, has had huge consequences, and that it has hampered tribal communities' ability to protect their own, to protect women within their communities. And in addition to that, the federal government, through the enactment of the Indian Civil Rights Act, has also limited tribal sentencing authority, so that until very recently, and continuing today in the grand majority of cases, tribal governments have a maximum sentencing authority of 1 year per offense. Under the Tribal Law and Order Act of 2010, that sentencing authority has been increased to 3 years per offense. However, that also requires that tribal governments comply with the requirements of that statute. And so what that has done is it has operated as a deterrent for tribal protection of Native women, to the extent that they are conscious of the fact that they will not be able to provide an appropriate sentence for the severity of the crimes. And there's been greater reliance and dependence on federal prosecutions, for example, as a result. In addition, there have been many documented examples of the failure of federal prosecutors to conduct investigations within Indian country. In many cases, it's simply because of the long distance which is required for witnesses to be able to cooperate and provide information. And in many cases, there, of course, have been documented instances of women, American Indian and Alaska Native women, who have experienced sexual violence, who were intimidated perhaps, or who also just did not receive a response, and they were unable to provide all the information and did not see an actual investigation completed related to the criminal act that they experienced. And then in addition to that, there have been many instances of federal prosecutors declining to prosecute reports of sexual violence within Indian country, in part because of the difficulties that are associated with identifying witnesses, the long distances that are required for those witnesses who are required to cooperate and testify in a jury trial. And so, all of these factors together have contributed to a federal failure to provide adequate protection for American Indian and Alaska Native women within Indian communities. In addition to that, there's also been a state role in contributing to this failure. So, for example, In those states which are PL 280 states, there has been weak enforcement weak law enforcement within Indian communities. And for example, Professor Carol Goldberg and Green Champagne in their book Capture Your Justice have documented the many ways in which the response time, the patrolling, carrying out of criminal investigations, the solving of cases, communication with tribal members has been insufficient and has left many people within Indian communities feeling that they did not receive fair and full protection by state law enforcement agencies. In addition, there are states like Alaska, which is authorized to exercise criminal jurisdiction under Public Law 280, and which has aggressively and historically challenged the exercise of tribal jurisdiction by tribal communities. And so Alaska, for example, had threatened to criminally prosecute Alaska Native villages, Alaska Native councils, which attempted to exercise criminal jurisdiction within their communities. And so states have attempted to impair the exercise of tribal jurisdiction, which lawfully had been retained. And that furthermore, in those states where states do not have conferred jurisdiction to prosecute crimes involving Indians within Indian country in Public Law 280 states, in those states which are not PL 280 states, there's a jurisdictional gap, and so states do not have the jurisdiction to prosecute crimes which do not involve both a non-Indian perpetrator and a non-Indian victim. So states have what we call McGratney jurisdiction within Indian country, and so they can only prosecute those crimes involving non-Indian perpetrators and non-Indian victims. They lack criminal jurisdiction in those instances where Alaska Native women or American Indian women are victims of crimes committed by non-Indian perpetrators. And so in addition, I mentioned that there are 3 governments which have a responsibility to protect Alaska Native and American Indian women, and the 3rd are tribal governments. Tribal governments share that responsibility as well, but because of the Oliphant decision and the jurisdictional gap which they have, they lack criminal jurisdiction to prosecute crimes committed by non-Indians, and so they have had their hands tied and have been unable to respond to many of the cases, since I mentioned that it is reported that in over 86% of the instances in which Alaska Native or American Indian experience acts of sexual violence, the perpetrator is reported to be non-Indian. So in those cases, the tribes lack jurisdiction over the perpetrator. So this is so this has all contributed to a inability to provide sufficient protection for Native women. And so due to the activism of scholars, the activism of very courageous, and I apologize for even mentioning that, but the activism of incredibly courageous women across the country who have experienced and who have been touched by this and who have been concerned and motivated to speak out against these harms occurring within Indian country, there has been an uprise in activism, and ultimately in 2013, Congress finally did respond by reauthorizing the Violence Against Women Act to include, for the first time, a Title IX, which recognizes special criminal jurisdiction for Indian tribes under certain circumstances. And so we very fortunately have Wilson Pipestone here, who, after I conclude my talk, will speak about the lobbying effort that resulted in this legislation. So under this Title IX, there's a recognition of tribes' inherent power to exercise special domestic violence criminal jurisdiction over certain defendants who commit acts of domestic violence or dating violence, or who violate certain protection orders within Indian country. And so that legislation follows reauthorization, which includes this special Title IX, will not take effect until March of 2015. However, there is also a pilot project which allows for the accelerated exercise of this special domestic violence criminal jurisdiction for those tribes who are accepted by the Department of Justice. And so This is very timely because just yesterday, the Department of Justice announced that 3 tribes had been identified as eligible to participate in this pilot project. And so I'll note them in a moment as soon as I go over the requirements and some of the key aspects of Title IX. Okay. I guess I have a habit of not going to the next slide on time, so sorry. Maybe it's when I teach property, sometimes I intentionally do not go to the next slide on time because I don't want the students to, discuss what they think about the cases first. Right, okay. All right, so here we go. So, so participation in the special provisions for domestic violence criminal jurisdiction under VAWA is voluntary. And in addition, there's no change to the existing scope of criminal jurisdiction that the federal government or that the states and the PL280 states have. There's no change to existing tribal jurisdiction within Indian country. And also, of course, there are these important covered offenses, which are limited to domestic violence, dating violence, and criminal violations of protection orders. And so what also is incredibly important to note regarding this is what it does not cover. So, of course, it does not cover those crimes that are committed outside Indian country. So, for many tribes, the disputes regarding the location of Indian country is going to perhaps prevent them from being able to exercise this expanded jurisdiction under VAWA. This legislation also does not address sexual violence or, domestic violence or dating violence that exists between 2 non-Indians. And so although that may occur within Indian country, the tribe will not have jurisdiction over those crimes. And in addition, what also is very important to note is that this special domestic violence criminal jurisdiction does not apply between 2 strangers. So although there may be an American Indian or Alaska Native woman who is a victim of some form of sexual violence, if that person does not have sufficient ties to the tribe, such as living or working on the reservation, and it does not fall under the requirement of domestic violence or dating violence, then the tribe will not have criminal jurisdiction in that case. So, for example, if a non-Indian comes onto the reservation to visit a tribal casino and commits an act of sexual violence against a Native woman and is a stranger to that woman, then that individual would not be covered by these provisions. The tribe would not have criminal jurisdiction over that crime. In addition, the statute's provisions do not cover child abuse or elder abuse. It does not involve violation of a protection order. And in addition to that, it's also important to note that there's a special section 910, which is a special rule for the state of Alaska that applies that these special domestic violence criminal jurisdiction provisions only applies to the Annette Island Reserve. So Professor Carol Goldberg is going to be speaking about that special rule for Alaska, and that is very limiting for Alaska. So, we anticipate that you can anticipate that there will be any questions regarding what kinds of ties are sufficient to satisfy this threshold of sufficient ties to the tribe living or working on the reservation. So, in addition, in order to exercise this expanded domestic violence criminal jurisdiction under VAWA, the tribe needs to comply with a number of different conditions. And so the tribe must comply with the Indian Civil Rights Act. The tribe also must comply with the requirements that have been set forth in the Tribal Law and Order Act of 2010. So those requirements had initially been set out, and VAWA simply cross-references those requirements. So they include, for example, effective assistance of counsel for defendants, the provision of free, appointed, and licensed attorneys for indigent defendants, law-trained judges, publicly available rules and codes, and reported criminal proceedings. And so what this is clearly going to require are substantial funds and resources available for tribes who already are stretched very thin in the exercise of their criminal law enforcement and the operation of their justice systems. And so there are tribes that are attempting to find the resources and support to be able to offer indigent counsel, for example, counsel for indigent defendants. And so, in addition, there are requirements for jury pools. There needs to be a fair cross-section of the community in jury pools, so you cannot systematically exclude non-Indians. And so some tribes are already questioning how they will be able to, how they will have the authority to be able to include non-Indians within their jury pools. And many are exploring, including, for example, tribal employees within those jury pools to include non-Indians. And so these requirements, as I mentioned, the main impediment is finding the financial resources that will be necessary to provide for these kinds of protections. Although money has been authorized by Congress, there have not been, as I understand, appropriations to date. And so tribes are applying through the Coordinated Tribal Assistance Solicitation, CTAS. And so that brings us to the fact that as tribes attempt to comply with these requirements by 2015, there have also been tribes which have attempted to apply to participate in the pilot project that allows for the accelerated exercise of the special criminal jurisdiction. So, the pilot project. In order to participate in the pilot project, tribes must protect defendants' rights under federal law and apply to DOJ, and then they need to be accepted, and DOJ needs to identify the specific start date. And so just yesterday, DOJ announced that the Pasquayati tribe of Arizona, Umatilla tribe, and the Tulalip tribe have each been accepted to participate in the pilot project. And on the DOJ website, you can also see the various document forms that those tribes have submitted as part of their application process. And I think that that's also a step forward toward sharing the required information that tribes need to be able to see other examples and models of how tribes are accomplishing the fulfillment of their requirements for this conditional jurisdiction. So for example, I think it was for the Pasquayati tribe, you can see not only their application questionnaire answers, but for the tribes to participate, you can find copies of their tribal court rules, tribal criminal code provisions. You can find tribal court directives that ensure that there's full compliance with all of the requirements. And this is in order to ensure that other tribes can look at these ways in which other tribes are participating and complying with the requirements. And then in addition, as part of the pilot project, there's also the creation of an intertribal working group. And so that intertribal technical assistance working group is created to ensure that even those tribes which are not actively participating in the pilot project, but who are looking to comply with the requirements by the 2015 nationwide rollout date, that they are able to share their best practices and share concerns, share strategies, and have active DOJ participation in that group as well. So some of the other tribes which have submitted applications, which notably were not included in the announcement yesterday, but perhaps will make part of another announcement in the future, included the Penobscot Indian Nation, the Ute Indian Nation, and the Assiniboine and Sioux tribes of Fort Peck. So we may see other tribes also announced in the near future, hopefully, who will be allowed to participate in the pilot project. So I know that this leaves a number of questions that you may have regarding challenges that tribes are encountering as they attempt to comply with these requirements, but I think my role is just to sort of provide that general overview, and then we can hear from President and Professor Goldberg's perspectives. So thank you.
Well, thank you very much. I want to first clarify that the Indian Law and Order Commission is not solely an administration creation. It is both congressional and executive branch, and as I will explain later, we have appointees by both branches of government that's been very critical to our functioning. But I need my PowerPoint up there. While you're doing that, I will take a point of personal privilege, because it's almost 44 years ago now that here at Stanford Law School, my interest in and career in federal Indian law was sparked. I was transferring here actually from the University of Pennsylvania Law School. Eventually, even after a year here, they let me have a degree, which was very nice of them. I was wandering into seminars looking for classes to take in my last year of law school, which I was very glad to know would be my last year of higher education before entering the world. And without really any background or knowledge of the field whatsoever, I managed to find myself in a Indian law seminar that was being taught, interestingly enough, by a UCLA law professor, Monroe Price, who was flying up to Palo Alto one night a week to teach this seminar. Interestingly also, another one of the attendees was a gentleman by the name of Rick West, who later became the founding director of the National Museum of the American Indian, now happily directs the Autry Museum of the West in Los Angeles. But in that seminar, Professor Price was looking for help in the development of the first teaching casebook in the field of American Indian law. And he basically put together a table of contents, looked around at the students, assigned us each a chapter, and I got assigned something I had never heard of before called Public Law 280. And I spent a lot of that semester in the Stanford Law Library working on that chapter for Professor Price, which ultimately became the first article I published in the field and really generated the interest that has driven my entire professional career. So I'm very, very happy to be here at Stanford. And now I want you all to just spend a second or two staring at that title, because I got very excited when I thought of it. Which button is the one I should press? The right, okay.
We were supposed to be at work.
Okay. All right. So Winona has done an outstanding job of laying out what VAWA 2013 made possible. And I'm going to be the sour note here, talking about what VAWA 13 did not acknowledge, what was left out in the cold. And in the course of this, I'm also going to elaborate on the work of the Indian Law and Order Commission, because, as you'll see, one of our recommendations is that this be repealed. Okay, so as you heard in the earlier presentation, there is a provision in VAWA 2013 that says that the sections 904 and 905, which I'll explain in a moment, apply only to the Indian country of the Metlakatla Indian community in that island reserve in Alaska, which means that any of the powers that are specified in those two sections are not going to be applying anywhere else within Alaska. Now, there is an effort to, in subsection B, to retain jurisdiction on the part of tribes with respect to 182265E, which is really dealing with the full faith and credit given to tribal orders of protection. But this is simply saying that they're not trying to reduce that, but any additional authority that might be granted by VAWA 2013 is excluded by the previous subsection. And just to make sure that the state of Alaska is reassured, there is a saving provision in C affirming that the jurisdiction of the state of Alaska is not going to be limited or diminished in any way. So what are these exclusions, 904 and 905? Well, 904 is the partial Oliphant fix that you were just hearing about. That is tribal prosecution of non-Indians for domestic and dating violence under limited conditions, as you've seen. It also included the potential for prosecution for violation of tribal protective orders. This is, by Section 910, not afforded anywhere in Alaska other than the Metlakatla Indian community. Section 905, I simply highlight here the language because the multicolored wording there is designed to show that 905 was expanding the tribal protective order capacity of tribes. And again, this is something that Section 910 does not permit anywhere in Alaska other than the Metlakatla Indian community. So enter the work of the Indian Law and Order Commission. What I've given you here is basically a visual that has the cover of our report. Show and tell. November 2013 was issued. It's heavy. And also a piece from the cover that shows you who the commissioners are. This is the inside cover. I'll explain that a little further. The Indian Law and Order Commission was established by the Tribal Law and Order Act, which you've heard alluded to as well. In 2010, there's a photo of President Obama signing it. There are 9 commissioners. We're listed here for you. As I was explaining earlier, only 3 of us under the statute are appointed by President Obama. I, along with Chief Judge Teresa Pauley from the Tulalip Tribal Court, and Ted Quasula, former head of BIA law enforcement. We are the 3 Obama appointees to this. There were 3 also appointed by the House. This was before the changeover to a Republican majority, so the majority party got 2, that was Democrats. The minority party got 1. Likewise in the Senate, 2 by the Democrats, 1 by the Republicans. So it's a bipartisan as well as multi-branch commission. Stephanie Herseth Sandlin, former member of Congress from South Dakota, Earl Pomeroy, former member from North Dakota, involved in the drafting of the Tribal Law and Order Act, were 2 Democratic House appointees, Tom Getty of California, very active in the California Attorney General's office and formerly head of the Conference of Western Attorney Generals, was the Republican House appointee. Then in the Senate, we have, gosh, our chair is not listed here. Oh, that's because this was, he produced this. Okay. So the two Democratic appointees from the Senate, one Troy Ide, our EID, our former U.S. attorney from the state of Colorado, and the other Jefferson Keel, who was then president of the National Congress of American Indians. I believe he is still lieutenant governor of the Chickasaw Nation. And then on the Republican side, the Senate appointed Affie Ellis, a member of the Navajo Nation who grew up in Wyoming and has been very involved with government affairs and Senate work with the Senate, and well known to Senator Barrasso on the Senate Committee on Indian Affairs. The Tribal Law and Order Act, just as a broad characterization, was a, I call it a lowest common denominator bill. I mean, first of all, you have to be taking note of the fact that it actually is a piece of congressional legislation that was passed, period. In order for that to have happened, there had to be agreement, which is what produces basically a lowest common denominator. And basically everything they could not agree upon was passed over to the Indian Law and Order Commission, I think, frankly, without a whole lot of expectations. Certainly not expectations of anything that was this heavy, both in content and in weight. The commission was created as a volunteer commission. There was no salary provided. It was all voluntary activity on the part of all of us. The funding was to be out of money that was unallocated or left over in the 2011 fiscal budget. If you can recall, that was a budget that was a very long time coming, and as a result, we got a very late start in operating. And furthermore, our staffing was to be individuals detailed to us from the Departments of Justice and Interior, which meant that they were set aside from their normal functions. Their agencies were losing out on their attention, and they were having to straddle the needs of their ongoing responsibilities and the work of the Indian Law and Order Commission. We were blessed, fortunately, with staff who were very committed to us. Jeff Davis from the U.S. Attorney's Office in Michigan, who was our executive director. Laurel Ironcloud from the Bureau of Indian Affairs, who was our deputy director. And fortunately, we also had a remarkable staffer from the Justice Department who volunteered, was not even detailed to us, who gave an enormous amount of time, Eileen Gary, who knew the ins and outs of funding, and frankly, without Troy Ide, who knew Justice Department because of his work as U.S. Attorney, and Eileen Gary, I'm not sure we would have been able to accomplish pretty much anything. Troy was a remarkable appointee. He is a lifelong Republican, was a U.S. Attorney appointed by President George W. Bush, one of those U.S. attorneys who actually wound up in some difficulty under the Bush administration because of his interest in and concern for Indian country. He was appointed by Democrats in the Senate. Harry Reid appointed him. The commission, I think, in probably the most important move we made of the entire body of work, chose him to be the chair. The result of all of this, frankly, was that we came up with a set of bipartisan recommendations. There is no dissenting opinion in this, and we can speak with one voice to Republicans and Democrats alike in the Congress. Wilson, you can talk about whether we're listening. Yeah. So here are things that we did. We had field hearings and visits to all of the BIA regions. We had many individuals testify before us representing Indian nations from all over the United States. Hundreds of hours of testimony. We also heard from federal, state, and local officials, from nonprofit organizations like the Annie E. Casey Foundation and other stakeholders. Among other things, this report chose an entire chapter devoted to Alaska. It was really not clear at the time we began that this is what we were going to do. A number of federal and state commissions over the last several decades have been trying to tackle the situation of safety for Native Alaskan communities, and they've all faltered. And we decided that we had to. And we decided it because of the trips that we made to Alaska. Normally our field hearings were held as a commission of the whole. Alaska is so big, and this visual is designed to demonstrate that to you, that we broke up into subgroups, groups of 2 or 3 at most, and went to different parts of Alaska. And we were hearing about tremendous distress there, tremendous distress. And we felt that we had no choice but to tackle the challenges that exist there. So part of the distress is a consequence of distinctive legal arrangements, which I will try to summarize briefly because I know we don't have a huge amount of time. But Alaska is a place where there are a number of thousands, actually, of native allotments and town sites that are held in trust by the United States. In 1936 amendments to the Indian Reorganization Act, quite a few of the 250 29 native villages in Alaska did incorporate under the IRA. Some of them did have reservations established under that framework. In chronology, the next important event is Public Law 280, which came along with statehood in 1958 and affirmed state jurisdiction. And then in 1971, the Alaska Native Claims Settlement Act, and I reference here competing narratives of Native empowerment and termination, because in my view, the Alaska Native Claims Settlement Act is really the last gasp of federal termination policy. It's really sitting there at the cusp between termination policy of the 50s and 60s and the self-determination policy of the 1970s. But among other things, except for that Metlakatla Indian community, it eliminates reservation status for Alaska tribes, and at the same time creates a network of regional and village corporations with the shares of those held by Alaska Native villagers. The Native empowerment narrative is all about the resource controls that are associated with the Alaska Native corporations, but the termination narrative is all about the challenge to reservation-based systems, which was a consequence, I believe, of the belief at that time that there were only really two drastic alternatives available to Indian country. That is, total federal control or total release from federal affiliation. Of course, the self-determination policy of the 1970s is trying to find a middle ground there, but at the time of the Alaska Native Claims Settlement Act, the only alternative to federal domination was perceived to be the creation of these corporations. Subsequently, in 1993, you see that even though there had been tremendous challenges to the tribal status of Native villages in Alaska, that government-to-government relations and tribal sovereignty affirmed by solicitor opinions, and in 1994 by a federal promulgation through Congress and LIS. But then in 1998, what we see is the U.S. Supreme Court, enter the U.S. Supreme Court in its Venati decision, denying that even the lands held by Native villages in fee, collectively, is not Indian country. Now, that doesn't necessarily address the issue of Native allotments and town sites, which remain held in trust, but it is taken by the state of Alaska to mean that there is just no Indian country outside the Metlakatla Indian community, and the state has full and complete control over everything that happens in Native villages. The BIA doesn't really help this because through its own regulations it says that under the Indian Reorganization Act, fee lands of Alaska Native villages may not be taken into trust. So the scene is set for disempowerment of Native villages and tremendous assertion by the state of Alaska of control over everything. That could conceivably have been okay, but there are huge challenges in Alaska. Challenges of distance, which that map demonstrated, lack of provision of service by the state of Alaska authorities to Native villages, a horrible cultural mismatch between the way justice is envisioned by the state and by Native communities, and I put here mentality. If I had more room, I would have put colonial mentality. What you see here in this photo is taken from the trip that Troy Ide and I made in 2012 to several of the villages in the northern interior of Alaska. The only way we could get there was on small planes. We were taken there by the Alaska State Troopers and by the U.S. Marshal Service. There you go, there's our one of our escorts. We heard in these trips, in unguarded moments, the expressions of the vision of the role of Native peoples in Alaska by state and federal authorities. Really, there wasn't a whole lot of difference. And it basically came down to this. If they're having trouble with subsistence there, if they're not getting the law enforcement service because it's too far, why don't they just move? Why don't they just leave? And you also heard that basically, it's too early to be trying to acknowledge tribal authority in Alaska because really we haven't settled in at the state. We haven't had enough time for the colonial project. Of course, they don't call it that. But we haven't had enough time for the colonial project to take full hold. We've only been a state since 1958. Those other states in the U.S. had much more time to get control. Give us more time. And that's kind of what we were hearing. They were very nice, and they flew very well in conditions that were kind of scary, but that's what we were hearing. And what were we hearing from tribal leaders at the Tanana Chiefs? We went to Fort Yukon community. We went to the native village of Galena and some other sites. And what we were hearing is their communities are suffering from too much violence, not getting enough service, not getting enough cooperation. Probably the most distressing thing we heard were from Native women themselves who said, look around you, every Native woman you're meeting today has been the victim of sexual assault. Every one. What were they seeking? They were seeking a greater role in policing and in dispensing justice. There is a system that the state of Alaska has created for what they call village public safety officers, VPSOs, and they are being sent out into Native communities unarmed. And tragically, during the course of the work of our commission, one of those VPSOs was shot and killed in responding to a call. So the Native villages are seeking a much greater role. Justice in the state of Alaska is far more centralized than it is in any other state in the U.S. It's not done by local counties or boroughs. Troy and I got before Alaska Native Public Radio, and we were interviewed while we were there in 2012, and we said some things about the continued existence of Indian country in Alaska through Native allotments and town sites. We set off quite a stir. Some rather vocal individuals who have long in the state of Alaska, well known to Bob Anderson, sent us outrage letters. We met with the state attorney general who said we were out of our minds to think that there was still Indian country in Alaska. And at the same time, we met with the Chief Justice of the Alaska Supreme Court, Dana Fave, who has been coming down through her court with decisions acknowledging child welfare jurisdiction for tribes in the state of Alaska and working in a cooperative way with the growing number of tribal courts that have been established in Alaska. Justice is being pursued in Native villages in Alaska. They're just not paying attention to what some of these letter writers are saying about the absence of their authority. So let me just try to bring this to a close by identifying some of the things that the Commission has done. We looked at the statistics, which are, I will just not recite here, but you've got them up there for you. They're very, very distressing. And one of the things we said in the report, you've got quoted here, we just said that the status quo is untenable, basically. And that if the villages and tribes are in a stronger position to take over justice from the state of Alaska, everyone will be better off. So here were our recommendations. Congress should overturn the Venati decision. The BIA should take land into trust that is currently held in fee. And there is a recent U.S. District Court decision that supports that authority, challenging what is in the BIA's regs. That the Interior Solicitor should reaffirm the Indian country status of allotments and town sites, and that Congress should affirm the inherent jurisdiction of villages and tribes over their territory. as you can imagine, this was, it has received a lot of attention in Alaska. Several of the commissioners, Troy and Ted Kosu and myself, went up to Anchorage in December of 2013, and interestingly enough, the tune of the Attorney General is actually changing. They're trying to negotiate some agreements. They're not, at this point, very well designed to recognize the authority of the native villages and tribes in Alaska, but the tune is changing. So we have recommended repealing Section 910. It was opposed, as you might imagine, by a large number of native groups. Senator Lisa Murkowski, who was leading this along with Congressmember Don Young, she was elected with a lot of native support in Alaska, and they are really unhappy with this. She tried to defend herself, and it was a big thud. She said, oh, well, I was trying to make sure Metlakatla wasn't excluded. Well, there's no reason why Metlakatla should have been excluded. That is a really, really lame excuse. And here is a quote from NARF's attorney, Natalie Landreth, complaining about separate but unequal treatment. And I think there is no other way to describe it. This is not the only bill that has been drafted with pressure from the Alaska delegation in Congress to exclude Alaska natives, and they are not going to stand for it anymore. When we were in Alaska and Anchorage in December, we met, the two other commissioners, myself, with the board of the Alaska Federation of Natives, which has representatives from the corporate leadership and with the tribal leadership in Alaska. And they strongly endorsed the Commission's recommendations and then had a conference call with Senator Murkowski in which they demanded that there be oversight hearings in the Senate Committee on Indian Affairs, on which she sits. So what are we seeing? We're seeing, as I mentioned, the Attorney General acknowledging now, he's not denying the problems at least, so that's a move forward, seeking these deputization agreements. They may begin arming the VPSOs, which would be some help, but the most important thing, I think, from the perspective of the Commission is that there will be oversight hearings in the Senate Committee on Indian Affairs next week, and keep the word out there, folks. The worst thing that can happen is if this loses momentum. So thank you very much.
Thank you very much. You know, this is about lame excuses. We'll get into Congress now, so keep that interesting. But what I'd like to talk about is VAWA advocacy and the situation of VAWA, including Alaska Natives, in a larger context of just how power is exercised in the United States. So the earlier panel discussed Supreme Court decisions and how those impact Indian country. And now we get into, through VAWA, how Congress has responded in some circumstances. And just I can recall, though, the first time I heard about the Oliphant decision, which was decided in 1978, I was 9 years old. And my dad was an attorney and a tribal chairman, and he made me go along with him to different tribal courts and to tribal council meetings, and sometimes these were long drives, and so he would say, you're going whether you want to go or not. So what he would do is he'd bring along like a stack of cases. You know, back then there was no Westlaw, it was printed out, you had to print each page out. And he would say, read me, okay, let's read this case to me. So we'd ride along in a long ride in the car, and he would have me read that, and I can remember one of them was Oliphant. And he would typically say, what do you think that means? And we would have a discussion. I would say, well, one guy got arrested, you know, I was young. And he would say, no, let's talk about what does this really mean? And that was kind of his way of educating me about these issues, and I was really thankful to him for doing that. But I can remember his conclusion about Oliphant is, it's going to be open season on Indian women. I can remember him saying that in speeches over and over. This is open season on Indian women. There's a hole in the law. There's not enough interest on the part of U.S. attorneys and FBI to prosecute these cases. And so they've got bigger fish to fry, and Indian women are going to suffer from this. And so I can still remember him saying those words over and over. And so as I actually went to law school here, I think I took common law in this classroom, actually, so it's kind of deja vu. But I always knew that I wanted to be a practitioner of law, represent tribes, and do Indian rights work. And so the Oliphant case, you learn as being one of those examples of really how power is just exercised against Indian people. I remember as I was teaching as an adjunct, when I was in the younger part of my career, and just studying the body of Indian law and realizing that this is just an exercise of power against people. There is not a consistency in the law when it comes to this. Precedent is ignored, and there's just an exercise of power. And so the more I learned that, and I was litigating cases in the private sector representing Indian tribes, the more I became interested in Congress and how Congress works and how there are solutions in Congress sometimes for the problems that Native people face. And so I ended up being, I call him a tribal advocate within the Congress, but the rest of the world calls it a lobbyist, so that's the one difficulty I'll just have to live with. But I can remember going to meeting with the tribal council of the Eastern Band of Cherokee Indians in North Carolina, and there was a councilwoman there named Terry Henry, and she said, it's a priority for us, and I want the tribal council to agree that we're going to work on the Tribal Law and Order Act and try to get an Oliphant fix. And she said, what's your impressions of that? And I said, I'll be honest with you, we are going to fight uphill on that. This is going to be very difficult for the Congress to accept, even Democrats on the Senate Indian Affairs Committee, our closest friends. So we made an attempt to, in the Tribal Law and Order Act, to have that included. And I can remember a friend of mine on the committee saying, we can't even get the Democrats to clear that. So not to mention Republicans, who some of them on the committee had hard views on tribal jurisdiction. So that effort did not last very long. As Dr. Goldberg said, when you're dealing with the Congress, and now Indian legislation is certainly the case, it is a lowest common denominator process many times. And so Indian legislation, if you even look at the history of the Indian Reorganization Act, you've got these places where smart people want to go with legislation, tribal leaders want to go, and it turns into what survives in a process, particularly in the Senate, where one senator has a lot of power. So that happened as far as the Tribal Law and Order Act passed, but this was not even a serious consideration. This was in 2010. So how did we get to the very good news of VAWA passing and a recognition of inherent tribal sovereignty, to exercise jurisdiction over non-Indians? How do we get there between today, the good news announced yesterday, and 2010? Well, it's largely about politics. So I don't know if you recall this, but Rush Limbaugh made a comment about Sandra Fluke. I heard her pronounced Fluck yesterday, so I'm not sure if it's the right way to pronounce it. But he referred to her as a slut because of her advocacy for women's rights. Then another candidate for the Senate, Todd Aiken, referred to legitimate rape. And there became this dialogue that happened among, in the context of an election, that caused women's organizations and women across the country to really take notice. And that ended up in a significant move in the numbers of women towards voting for Democratic candidates. So that set a new stage where the Violence Against Women Act became the centerpiece of women's rights legislation. And Indian issues became an important part of that. So that legislation was introduced again, and the three problem areas for the Congress were Indians, lesbians and gays, and immigrants, or in the views of some folks, illegal immigrants. So why not extend protections to them, but this was political? So that politics began to play out. And the good news is I had the fortune of being able to work with, because of Terry Henry, that same tribal councilwoman from Eastern Band Cherokee, it was because of the commitment of advocates and activists like hers that there'd been a groundswell beginning over the years about this. And there had been many years of recognition that this was wrong. And so a lot of work that they had done over the years had led to an opportunity, relations with the larger women's organizations, relations with, on an international basis, is raising this as a human rights issue. And so all that work had been done. And so when the VAWA bill came out, women's rights were front and center to that legislation. Now, typically, when it comes to Indian legislation, nobody cares on a larger basis. On a larger world does not care much, unless you run into jurisdiction over non-Indians or something like that, or if it's a gaming issue where land or other issues are at stake, then that's when the lowest common denominator process goes into full effect, and we usually have a lesser piece of legislation. In this case, we walked into Congress with this kind of wave of women's rights, and the women's rights advocates in Indian country had made sure that this was a centerpiece of the larger women's rights effort through the Violence Against Women Act. So we walked into this. The interesting part about this is, on the Senate side, there was one primary leader in the Senate on this issue, and that was Senator Patty Murray from Washington State, very familiar with Indian rights, a long-time friend of the tribes. And she made a commitment at the beginning that said this bill will fail if the Indian women part of it is not in. She made that crystal clear from the beginning, because we were always nervous that as this goes along, Native women being a smaller part of the larger Indian rights movement, that we could be compromised and fall out of it, because we were a centerpiece that was identified as a problem by opponents of the bill. So that advocacy effort began in earnest. And it was interesting, the arguments that were made against the tribal divisions. One was that this is just unconstitutional. You cannot have a tribal court exercise jurisdiction, the way it was said, over white guys. Can you imagine a tribal court having the right to take away freedoms from a non-Indian and putting them in jail? We're talking about, this isn't whether or not, we're not talking about services to Indians, we're talking about jurisdiction. And so there was hard opposition on the basis of that exercise of power. Then there was this other argument I thought was interesting. This was concern about its payback time if we let this happen. What happens if we give tribal courts, this is real expression, if we give tribes jurisdiction here, they will impose upon non-Indians hundreds of years of oppression that have been imposed upon them, and they will be treated unfairly. We just cannot accept that. We cannot allow that to happen. And these are primarily arguments from members of Congress from states with high Indian populations, by the way. You know, another issue that was made, another concern that was raised is we're not sure there's a problem here. You say there's a hole in the law. There's no real statistics that we believe are valid that demonstrate that there's a real problem. You've got Justice Department statistics, but I can poke 100 holes in that, and that's not real. And the anecdotal evidence of Indian women who testified, and let me tell you, the testimony of these unbelievable women was an enormous part, an important part of this. Diane Milledge from Southern Youth story, I remember the first time I heard it. Her story was she met the man of her dreams. He happened to be a non-Indian man. They moved to her, they got married, they moved to her home on the reservation. And it wasn't too long into their marriage that he began being abusive towards her. And then that abuse just continued and escalated, because one of the things I learned in this process was that if you don't intervene early in these domestic violence cases, that's when they escalate and it leads to real harm or death of the victims. But her situation was, it started off with lesser acts of violence against her. It started to get worse. She said, I'm calling the police. And he got scared. He was worried about that. She called the tribal police. We said, we can't do anything about it. We can send it on to the U.S. attorney. And they called the state police. We have no jurisdiction on this issue. And so it became a helpless situation for her, where one time there was another fight between the two of them, and she said, I'm calling the police. And he picked up the phone and said, let me he actually called the state police and tribal police, said, hey, I overdid it again, I'm sorry. What are you going to do about it? And nothing was done. It wasn't until she was at work, she worked for the Bureau of Land Management, her husband came. She had said, I'm going to leave you finally after all this. He came to kill her. And he tried to shoot her, and he shot one of her co-workers who was trying to be helpful. And it wasn't until that time that he was actually charged with anything. And so her story, again, if the tribal courts would have had authority to intervene there and do something about that, maybe she would have not, maybe this non-Indian worker at the Bureau of Land Management would not have been shot. But there were many, many anecdotal stories. So those were so they're initially, and these are sometimes friends of Indian country here that are saying, you don't have enough statistics. Our response was there's a hole in the law, and it's having serious impacts. But it's difficult to get data about this because, one, it's an inherently difficult area to collect data on because any kind of domestic violence, you have problems where there's an incident and then the spouse does not want usually her husband or boyfriend to go to jail. So it's hard to quantify the real problem. But after a while, mainly Republican officers were saying that went from saying there's no problem to, okay, we buy that there's a problem. Now how do we fix it? That was a major leap forward for them just to acknowledge that there's a problem. So the next part of it, I can remember, this is a little bit of a war story here, so just bear with me. We have a meeting with Senator John Cornyn, who's on the Judiciary Committee from Texas, conservative Republican. And Cornyn's folks said, sit down here, we want to talk to you about this. There's a vote coming up. We knew we had the votes to pass the Senate. They said, but you want to try to reach a compromise with us because the last thing you want to ever do is deal with Eric Cantor in the House of Representatives. That is the last thing you want to have to do, trust me. And then there was this interesting relationship between these two offices and that the staffs had gone back and forth and everybody knew each other very well. So it wasn't an empty threat. So the guy said, we brought our pajamas, we're going to be here to negotiate all night if we have to, because this bill's on the floor on Thursday, this is Monday or something. So, of course you walk in, and this is again about representing Indian tribes, we don't have authority to negotiate for all of Indian country. Even if we had the leaders of the VAWA task force, which included Terry Henry, in the room, you don't get to, well, some people I think have done this, but I certainly don't think that we had authority, and I don't believe that would have been appropriate to do, particularly when we knew we had votes. But so we decided not to bring our pajamas and negotiate on the Senate side. The bill passed with the jurisdictional provisions in there, reaffirming that tribes have the inherent sovereign authority to exercise jurisdiction over non-Indians in these certain circumstances. The limitations have been set forth. So it passed the Senate, but then you're on to the House. Now, if you watch the news or if you're reading the newspaper much, you know that the dysfunction of Congress in dealing with the House is particularly difficult. Now, our advocacy, the Speaker of the House, John Boehner, had made clear that Eric Cantor was the go-to person on violence against women. Cantor's from Virginia, very limited involvement with tribes. He's hearing from the chairman of his two committees primarily on this issue, Natural Resources, which is Doc Hastings from Washington State, and Bob Goodlatte from Virginia, who was the head of the Judiciary Committee. They're both saying absolutely no way we're going to create an inherent jurisdiction in Indian tribes. So Cantor was trying to play more the arbiter of his own caucus and trying to find a solution because he did say, I'm convinced there's a solution, we need to find a way to fix this. So they came back and said, our solution, and this is take it or leave it, is more federal delegated authority to U.S. attorneys. And we'll try to find a way to get more resources into those federal, to the FBI and U.S. attorneys. We're not going to agree to inherent jurisdiction. We believe it's unconstitutional. So that's what our offer is. Now, if you want to talk about on the fringes of what that means as far as federal delegation, we can talk about that. And it was interesting. Tribal leader women that I had the honor to work with, and this was mainly because Terry Henry was the co-chair of the Violence Against Women Act Task Force for the National Congress of American Indians. I can remember sitting in a room with her, the other co-chair, Juan Amago from Southern California, Deb Parker from Tulane, and Fawn Sharp from Washington State, the chairwoman of Quinault, and they said no compromise. Absolutely not. So we went back into those offices saying, we've compromised enough. Alaska has already been taken out. That's already a function of what's happened from that delegation. And they decided we cannot overcome that at this point. And so we went into the House vote saying this could fall apart. There was even some signals from some of the women's organizations that Indian women don't want all of this to fall apart for everybody. You really don't want that for everyone, right? And these Native ladies said, forget it, don't even question. We've been there with, but there was this constant reaffirming alliances among the women's organizations, the tribal organizations, that had to be shored up from time to time. Because from time to time, some of them thought about, well, what happens if the LGBT community falls apart? What do we do about that? Do we say we'll leave behind? There was a lot of those conversations. So that advocacy continued. There was an interesting thing on the House side, House Republicans. Have you heard of the Hastert Rule? If you've heard of this, but the Hastert Rule is basically the Speaker saying, we're not going to pass any legislation unless a majority of the majority with Republican control agrees to it. So we're not going to pass bills where a minority of House Republicans agree to something and they need Democratic votes. We want to have all of at least a majority of the Republicans in the House agree to it. And initially there had been a statement that we're not going to pass a VAWA bill and we're going to make this subject to the Hastert Rule. We're not going to pass it without that help. But because of the overwhelming politics associated with women's organizations this last election, and I'll give a lot of credit to Republican women in the House. Kathy McMorris-Rogers, you may have just seen the response that she made to President Obama's State of the Union address. She was a key person. We actually went, another quick war story, with Deb Parker, Terry Henry, and Fawn Sharp, all the elected tribal officials at the highest level within those tribes. We asked for a meeting with her, and they say you can meet with the staffer. Well, not the highest level staffer either. It was not a good signal from her. We go to meet with her. Morris Rogers is coming out of her office as we're going in, and me being a lobbyist, I try to grab her and say, hey, can we talk to you for just a minute? So she stopped and she said, I believe that you're just being partisan here. You're just taking the side of the Democrats. That's my concern. She was very direct about it, and we said, actually, no, there's a Republican compromise supported by Tom Cole, a Chickasaw from Oklahoma, and Darrell Issa, Republican from Southern California. And she said, you are supporting that? And we said, absolutely. That's what we came to talk to you about. Never had seen this before. She said, turn around, I'm going back to my office, come with me. Got more senior staffers in the room and said, let's figure out a way through this. Later that day, we go to speak with Patty Murray again, who's our champion on the Senate side. And Kathy McMorris-Rogers calls her and says, I want to negotiate a deal with you on Indian provisions. She said, don't negotiate with me. Talk to the ladies that were just in your office. That's who I'm taking cues from. So it empowered Native women in this effort. They took a no compromise position. I helped advocate for that. And then the vote came down to that they decided what we're going to do is we're going to put together a Republican bill, VAWA bill. It had the federal delegation and their stuff we didn't like, but they tried to pass their own sick Republican bill. And because of the pressure of women voters, a lot of Republicans refused to support that bill. So as an alternative, Eric Cantor, to his credit, he was vilified, I think, unfairly. He said, if we don't pass the Republican bill, we'll break the Hastert Rule and we're going to vote on the Democratic passed bill. So once that happened in the Rules Committee, we knew that vote we were going to win. So that bill did pass with limited Republican support. 100% of the Democrats, including those that were trying to fall off because of concerns of criminal defendants' rights, they all stayed together and the bill got passed. Now, very rarely do you see a situation where Congress fixes an India decision of the Supreme Court. There's a couple of examples. There's Durofix, progeny involvement. There's a specific Osage case where that was fixed about membership of the equivalent, where the courts had decided certain rights to belong. And then here you have, again, a recognition of inherent sovereign authority of tribes to exercise power. Now, What does this all mean? Does this mean that every time we get a bad decision in Venati or Carcieri, what are the opportunities for tribes to go to the legislative branch and get some sort of fix? Now, I think it's encouraging that Congress has recognized this, and there's been a debate, at least with this Congress, about reaffirming inherent sovereign rights. But it's still a very difficult process to deal with. Right now, we've got a very difficult Congress. There's two warring camps that are at odds like never before in the history of the United States. So trying to get something through that sort of partisan environment is remarkably difficult. But I will tell you that there is, I think, opportunity. You look at cases like Carcieri, and we'll talk more about this in the beginning panels of the race of Indian lands. But the Congress, I think now, this is changing, and this is just, again, exercise of political power. The judicial power that's typically been exercised against Indian tribes in the last 15, 20 years. Used to be it was a place we could go for protect rights. It's no longer. It's become a much more dangerous place. Congress and tribes are more engaged there, different than what we used to do. When my forefather signed treaties, they expected when they went to Washington, D.C. and signed them that would be something that would be lived by. As we all know, all of those treaties have been violated. But I think now tribes are becoming more and more sophisticated about engaging the Congress and trying to impact elections. And now I think you'll see this in the context of Alaska, as Dr. Goldberg mentioned, in states like Alaska, where you've got, again, just talking about politics here, where Alaska Native votes matter. And you see Mark Begich and Lisa Murkowski and Don Young saying, wait a second, I've got to worry about getting reelected. This matters to that level, then I think good things can start to happen. That's not the case in most of Indian country, unfortunately. But also the difficulty is we caught a wave created by Rush Limbaugh, by Todd Aiken, that led to changes in election. That's what happened. That's the power, how that power was exercised. And because the larger women organizations stuck together with Native women who I think just did a remarkable job of thinking this through and advocating, telling their stories, and making a difference that this legislation has done. So thank you.
So Carol, you mentioned we were talking about the lowest common denominator. When I was down at your conference at UCLA, I noticed that there were some things that were left out of the Tribal Law and Order Commission's report. Or at least I gathered there was a little subtext about the Riverton, Wyoming diminishment issue on the reservation and EPA's Clean Air Act rule. And I guess if you could answer this, could you name a couple of things that you wish had been in the report but that were not included?
There aren't that many, but let me just explain that there was a conference at UCLA recently that was specifically focused on the report of the Indian Law and Order Commission and UCLA's American Indian Studies Center, led by Angela Riley, organized it very beautifully. And one of the speakers, Bob Clinton from ASU, highlighted the fact that a whole set of issues relating to the definition of Indian country outside of Alaska were not really addressed in our report, and I think that's true. We did not tackle the whole set of diminishment issues that frankly do have a big impact on the successful implementation of policing and criminal justice. Now, we do have a number of sections in the report, a whole chapter devoted to intergovernmental cooperation, which I would view as kind of a workaround that set of problems that arise from the checkerboarded or otherwise not very uniform state of Indian country in many places. So I think that is probably the biggest area that the commission didn't address. I suppose what you could say is that we addressed that issue more effectively for Alaska than for any other part of the United States. That by tackling the problems in Alaska and saying that villages should have authority recognized over all of their territory, we were doing more for them than we were doing for other parts of the country.